Well, hello. Are you guys tired yet? We're very excited that you chose to join us at this workshop. In case you're in the wrong room, this is the Pesticide Litigation Threats to Justice. And you know, we thank you all for being a part of this wonderful day. And this workshop is, you have heard a lot about kind of legal actions and challenges that have been directed towards lawmakers, regulators, you know, the government not having the right standards, not doing the right risk assessments. But often what starts all the work that we do at our organization at Beyond Pesticides and at NCAP is the individual and what's happened to them individually, be it from pesticide drift or, you know, the poisonings or whatever else that, or concerns about toxics or just generally noticing things happening in their environment. And it's the individual and that kind of interaction that also has a very important part in kind of our challenges and fight against, you know, controlling and getting better protections against pesticide. And so we've put together this excellent panel of people who have actually done the challenging and people who are part of the representatives and doing the legal fight on an individual and personal level, and wanted to bring that to you all. And so we are going to start off with Rosemary Bilchak, who, along with her husband, has set legal precedent that pesticide drift is trespass in and of itself. And that is a huge step. Prior to this decision, to which she was an integral part, trespass required proof of damages. And the judgment was handed down in Colorado in July in 2012. Their neighbor contaminated their organic farm with the organophosphate insecticide malathion and would not stop weekly spraying. And so they took to the courts, and she is going to tell you all about her experience with that.
Well, I'm going to answer this question in the affirmative. So that's the first. We come from a place called the North Fork Valley in western Colorado. It's a triangle of 3 small communities, the largest of which is 1,500 people. So this is a very tight little community. The community is made up of ranchers. There are 3 coal mines, so there are hundreds of coal miners. In the 70s, there was an influx of hippies, rainbow people, and trust funders. And now there is also this huge, that's the largest concentration of organic farms in the state of Colorado. There's small organic farms. There's bigger farms out by Denver, but this is the highest concentration of small farms. Well, as you might imagine, this mix is ideologically contentious. And to say that the political situation is acrimonious is an understatement. What happened is that these people then have a head-on battle, and what it really manifested itself in what we call the mosquito war. And I love the fact that Rella just talked about this. In Colorado, there is a concept under the Constitution called a special district. And a special district is to allow for people to do local control of things like sewage districts, fire districts, and that kind of thing. And they are essentially unregulated. The only thing that you have to be able to be on one of the boards is enough friends in the audience to vote for you. So in the case of special districts that handle mosquito control, you're dealing with something that's really serious in that you have people with no public health experience making public health decisions. Well, the mosquito control district in 2006, actually for many years before that, but in 2006 when when the West Nile virus was really hot, had a weekly fogging protocol. So they would go out and fog 4 nights a week, different areas of the district, and the 5th night was left over for double fogging or for fogging places that, you know, maybe weather had precluded them from doing previously in the week. Well, as a consequence, we had malathion-resistant mosquitoes. And I called CSU, Colorado State University. They sent out a graduate student. They performed a study, and they actually proved that we had malathion-resistant mosquitoes. We also had the highest per capita incidence of West Nile virus. Your chances of getting West Nile in the area under the jurisdiction of this mosquito district was 1 in 113. And that should be 10 or 100 times more than that or less than, however you want to look at it. But it's an incredible statistic, especially when you consider that 80 to 90% of the people who get West Nile never know that they have it. They're asymptomatic, and this is reflecting only those people who were sick enough to go to the hospital or report it or get the testing done. So I had a personal interest in stopping this because I felt that it was not safe for my community. But the other thing is that people who are subjected to spray really feel that they're safe. It's a very smelly process, it's visual, and you can hear it coming from a mile away. And so people think they're safe and they take fewer personal precautions, and the number one thing that you can do to protect yourself from arboviral diseases, which are mosquito-borne diseases, is personal precautions. So in fact, there was a study that was done between Colorado, in Greeley and Loveland. One of them had a spray program, one of them did not. The one that did not had fewer incidents of West Nile because people felt like they needed to take care of themselves. The other reason was because we had an organic farm, and so we wanted to stop the spraying for certification purposes. And finally, I have a husband who has a very, very rare form of leukemia, and he's pesticide sensitive. Now, I think that everybody is pesticide sensitive. I think everybody should be free from pesticides. But, you know, I had this extra goosing along. So I went to the CDC, I went to the state and federal legislators, I went to the governor, I went to the health department, and I tried to get help to stop this program of spraying. The only answer I got was, it's a local board, you need to take over the board. So the next little bullet point on here is we put together a campaign to take over the board. Now, my background is chemistry, physics, and math, and so, I mean, computers. And so what I want to say here is I had no political experience whatsoever, and yet we put together the first campaign in this area. The message I want to convey is you can do anything that you need to do if you're motivated enough. I got together with two other women, one of whom was motivated by the fact that her children, very small children, had been sprayed while on their bicycles. All right. So we put together the first political action committee in the county. We actually collected monies. We put out flyers saying who could vote. And that was a big problem in previous elections, that people would come to the board or to the voting poll and say, you know, I want to vote, and they'd say, no, you're not allowed to because you're not a landowner, or whatever it might be. Well, special districts have special rules. They're very convoluted, but we made sure everybody knew what those were. And we also said, if you get to the polling place and you don't get a ballot, demand a provisional ballot. So we had registration campaigns to get people registered to vote, including a youth thing. We had to get out the vote phone banks, and we even did those awful robocalls. I hate those things, but apparently they're effective. The day of the election, it came down to a tie. So went to provisional ballots, and we spent the next week and a half figuring out who got a provisional ballot, why they got it, were they on our side, and making sure that if they were, to get that ballot, you know, counted, get that vote counted. We won. At 1,265 votes, we won by 9 votes. The message here, your vote counts, especially in these local elections. Right, so we implemented a science-based mosquito control program. We focused on all the things that people had talked about earlier in the day. We had finding, mapping, treating the larvicide sites. We had, you know, the idea between, the difference between doing larviciding is that you throw this product in the water and it kills 100% of the mosquitoes that are in there. If you take spraying and you try to hit, it's like taking a machine gun to hit the fly that's on the wall. It's very, very ineffective, and obviously not, it doesn't really help as far as the disease is concerned. So I also wrote a grant to find the GIS software to get that. We were awarded that, and we mapped those breeding sites, and then took that and coordinated with the county departments, the GIS department, and overlaid that on their site so that they could go ahead and put this out to the public, because transparency in this district had been quite an issue. We had a very, very tight budget. We're talking about tax-based funding, and you have a population of maybe 4,500 in the entire area. So we have a very, very tight budget. An interesting thing is that the election is held in May. We didn't take over till June. You're well into the mosquito season, and more than half of your funding has already been spent by the previous board. So we coordinated 40 volunteers. They did everything from setting traps 5 to 6 nights a week. They would bring those traps in. We had to go over the learning curve of trying to figure out how to identify all those mosquitoes, sort them, and we took the ones that were Culex, the West Nile virus potentially carrying ones, sent them off to the health department, coordinated with them. They did the West Nile virus testing, and wherever we found the positives coming back from that, we would do spot spraying. That was our gift, I guess, to the people who were really into spraying. We felt that we needed to accommodate at least that much of it, saying, if we find West Nile, we will spray that area. It's a fascinating thing because people really came forward and volunteered to do a lot of this stuff, including, sitting there with a microscope for several days a week out of their summer, every week. Consequently, we had a huge reduction in the human West Nile virus cases. However, not everybody's happy. Here are a couple of exact quotes from people. If I have to breed mosquitoes to get sprayed, then that's what I'm going to do. All right, so they would go out of their way to find and create breeding sites, let the irrigation run or whatever, till they created intense breeding sites. And we're talking thousands of mosquitoes in a trap at night. And Rella had talked about there was a threshold of 100 for some people. All right, the other one was, this is from my neighbor. I don't believe in math. This came from the fact that his wife had gotten West Nile virus in 2006. She was very seriously ill, and she came home several months later. And this was during the time when the old board was in power, and because they were his friends, they would come around and they would drive all the way around his house spraying. Well, my job was to try to go over there and convince him to connect the dots. You've been sprayed all the way around your house every week, and you still have West Nile. Maybe spraying doesn't work. Well, I also brought up the statistics, the 1 in 113 chance of acquiring West Nile. That was the statistic at the time. And he basically just got red in the face and started saying that, he just got mad. And I said, well, he goes, I don't believe this. I said, well, it really is statistics. It's just, here's the population, here's the number of cases we have, the rest of it's just math. And that's when he said, I don't believe in math. And then he said, these are my friends. So in ousting this board of people who didn't have any public health experience and did weekly spraying, we had really made some enemies. So anyhow, he decides that he's going to go ahead and take things into control by buying his own fogger. Right, so the timeline of this is a little bit long, but on July 6, 2010, we get fogged. And I called the Department of Agriculture. The Colorado Department of Agriculture is the entity that's responsible for enforcing the Pesticide Applicator Act. They came out and they did testing several days later. Now, the chemical that he used was malathion. It's an organophosphate, and it has a half-life of 3 or 4 days. We also had 100-degree days at the time, so it was really deteriorating. And even after 3 days, they found significant amounts of malathion. In fact, they found more malathion on our property than on his. So we're wondering who he was really spraying. He continues to do weekly fogging. Flip this over here. We hired well, actually, first of all, we got a mutual friend, to go over and talk to him to see if we could get him to stop the weekly fogging. And the friend came back and said there's no way he's going to stop. We hired a mediator who went over and came back with his tail between his legs saying he's not going to stop. We finally hired a lawyer who wrote pretty strongly worded letter that said, you know, they're very serious about this. They want you to stop, and otherwise they will file charges. And he basically said, so sue me. In fact, this came a little bit later when he was under oath during his deposition. Our lawyer asked him, if you knew beforehand that your spraying would kill Gordon, my husband, who has the leukemia, would you continue to do your weekly spraying? And he said yes. So at this point, we feel we have no options. We filed a complaint in district court. In April of 2011, there is a cease and desist order issued by the Colorado Department of Agriculture. They found that he did not have a license. He had sprayed non-targeted areas. They actually called it trespass. The fogger had not been calibrated. He had had an inappropriate flow rate, and he didn't even possess a label, no less know what was on it. And if you are involved in application of pesticides, you know the label is the law. Unfortunately, he was covered by an umbrella policy by State Farm, and they brought in lawyers who went to the Department of Agriculture and significantly watered down the cease and desist order, getting rid of the trespass charge, and they took a 2-year-old calibration to say that, oh, well, it was calibrated even though the law says that it has to be calibrated every year. So my message here is if you expect some regulatory agency to protect you, then you may as well give up now, right? Right. In the summer of 2011, this fogging is starting again. We have now gone through a couple of lawyers. We have we filed for a temporary restraining order using the Department of Agriculture's. There's more malathion on their property than on his, and we received that. So we're safe for that summer. However, unfortunately, in August of 2011, we lose our bid for a preliminary injunction. The preliminary injunction has a higher standard than the permanent injunction. So there are a few what they call Rathke factors that we did not meet. We also were unfortunate enough to have a brand new judge. It was her first day on the bench. Somehow she got sucked into their need to spray to protect their health argument. One of the things she said was we could not prove that there are actual health impacts. There was only the potential for health impacts. And the the preserving of the status quo, since there was spraying beforehand, then spraying should continue. Right? So in April of 2012, we finally get our permanent injunction hearing. A couple of months later, we actually get our order, which says, yes, indeed, it is trespass. So what we got then was this precedent. The precedent says that pesticide drift is indeed trespass, and there's no proof of damage required. Up until this point, the EPA had said you need to prove that you're bleeding from the ears, and you have to prove that that's a result of the pesticides, or you have to lose your crop or something like that. The judge was very good at preserving the neighbor's personal property rights by saying that, all the rest of these things are part and parcel of anybody who would be a legitimate applicator, other than the 150-foot setback. And that was because he had put up, the machine puts up a 150-foot fog. Right. I said before that he had been represented by the insurance lawyers. They have very deep pockets, and when they have these deep pockets, they will bring up superfluous and extraneous things that are just amazing. I want to refer you to Jerry Spence's book, And Justice for None. The premise there is that we have, as taxpayers, put together a legal system and a court system that we pay for that really only represents the insurance companies. The extraneous argument I wanted to give as an example is we have an irrigation system that feeds into a cistern. We use that as a settling pond. We then take the water out of there and sprinkle our gardens. One day a health inspector shows up and says, we understand you're using a septic system for your garden. I said, it's a cistern. Come take a look. He looks, he says, it's a cistern. You can do anything you want with that water. He writes up a report that says, it's a cistern. They can do what they want with that water. We get into the courtroom. that septic system keeps coming back. Even after we had put in the exhibits or the report from the health department as an exhibit, it's like they beat this dead horse, and that's just one example. They have the money to hire incredible expert witnesses. There's a guy named Robert Peterson who has worked with the industry for many years. He's at the University of Montana. He gave his deposition, or his testimony was that he had a model where he showed that if Gordon and Rosemary were running behind the sprayer, running so that we have a higher respiratory rate, and we're in our underwear so we have complete skin exposure, that we would have 3 pennies worth of exposure. And that was in comparison to the EPA standard limit, which was 10,000 pennies. You better believe this guy makes decent money doing this. He charged $30,000 for that one appearance. Okay. Luckily, our lawyer came and said, where in your model do you show a 65-year-old male with hairy cell leukemia? But he's a very scary agent because he's very papered and has a lot of background. He authored a motion to get rid of the Colorado Department of Agriculture testing data. He said that they were not legitimately good at or not able to do the testing. Can you imagine what that would have done to our case if they had, succeeded in saying, you have to throw out the testing data? Your personal life is invaded when you do these sorts of things. I don't have Facebook. I was very careful of my calls. And you actually impose a self-isolation because, first of all, in a community that small, you don't want the word getting back. You also don't want to contaminate your jury if you happen to have a jury trial. So all of a sudden, things get very tiny, and it's a very stressful situation. In this case, there were over 120 pleadings. And that's each one of those means that your lawyer has to spend a half a day to a day responding and dealing with whatever it is that they're throwing at you. Examples of that would be a determination of law, to deny our right to a permanent injunction hearing because we had lost the preliminary injunction, and therefore that was good enough. The judge luckily said, no, that would deny them the fundamental right. They asked to replace the judge. And then finally, this last one, because they had used their need to spray was based on the fact that the grandmother had West Nile and they had an autistic granddaughter. Now, I'm sorry, but autism and organophosphates, but somehow they've made the correlation that they needed to do that. So we asked for their medical records so that we could rebut what they were saying. They said, no, you can't have them. We then went to the judge, said, you have to compel these records. The judge said, yes, you need to provide them. 3 or 4 days before our hearing, our permanent injunction hearing, they went to the Colorado Supreme Court and asked them to overturn the judge's statement. Well, the Colorado Supreme Court said, that's ridiculous. It's the basis of your statement, your argument. You need to provide those records. However, even though we won that, it delayed it by another 3 or 4 months, and so we ended up having a long time in there. I want to say it was a personal hell. I'm going to skip through this mostly because it's 2.5 years of sleepless nights for me. I talked about the social isolation, and then the financial burden is inordinate when you're taking these things on by yourself. So why would you do this? Well, here's a sprayer. If I turn, can you hear me? Okay. Everything to the left of the roadway is our property, and all the stuff in the foreground is our property. You can see the fogger and the fog coming out. Also notice that this is not night. And to hit a mosquito, to kill a mosquito with fog, you must hit it in air, right? So I don't know what he's really fogging. Here's the same night with the fog across the fields. Those little black dots on the right-hand side are cattle. To give you some idea of the perspective. And this, I think, was the winning shot. I was actually choking when I was taking this. Everything you see is our property. All of that is drift. And behind that drift, there are 2 houses that you cannot even see. They're obliterated by the fog. Okay, so you do this because you have to. What you need is endurance for the long haul. These things last forever, years, right? You need a thick skin. You will be personally attacked. You need the right lawyer. All right, we went through several, and I think that the highest point for me in this is you have to be very aggressive in finding people, and if you find someone that you cannot work with, even if they happen to be the good guy, it's tough. If your approach is to really be involved and organized, which is going to be down later, you need to have somebody who will accept your personality for that. You need expert witnesses. We had an organic farmer talk about what it takes to become organic. We had a mosquito control person come out and talk about how if an individual goes out and does spraying, they undermine the community program. We had the neighbor beekeeper who said, I don't want my bees being killed. We had physicians, of course, as we talked about. And then we also had Dr. Susan Kegley, who is a fate and transport expert witness, and she talked about the size of the particle that goes up into a wind of 1 mile or 2 miles an hour, whatever it might be, and how far the contaminant might travel. Absolutely essential to have good expert witnesses. I said you need lots of money. You need organizational ability. I would recommend that you keep a log and spreadsheets. I have a spreadsheet of every attorney and every expert witness I talked to, their contact information, what they said, who they referred me to, and when I contacted that person. Invaluable when you're trying to put this together, because you will forget. And then finally, you need proof. So the proof is, okay, so the proof is, I took pictures. The other thing that you need to know is that sampling is critical, but anything that you touch is suspect. So it will be thrown out of court. I did take samples, paid for them to be analyzed, and when they came back, it was like, you can't use that because you actually touched them. So in a place that's 5 hours west of Denver, in the middle of no man's land, it was really difficult. So again, back to that motion that the other side put in about trying to get rid of our sampling data, that would have been really detrimental to us. Skip that. All right. Finally, what's the point? The point is that pesticide drift is trespass. This has been set. All right, so you want to be able to use that. Right now, it only applies to 1 district in Colorado, and this needs to be cited by people so that it can be expanded. One of the reasons we felt that they did not appeal it was because the appellate court would then make it statewide. Right now it's only in 1 district in Colorado. So please take this, run with it. If you don't use it, then everything that we went through would be in vain. I have some resources up here, and I also have a, what do they call it? An op-ed piece on us. This was also covered on Huffington Post, if you wanted to look it up there. And I have a few copies of some of the motions and the judgment and that sort of thing, if anybody's interested in that. Thank you.
Thank you, Rosemary. Okay, next we are going to be hearing from Christopher Funk. Christopher is a graduate of Willamette College of Law, where he also earned his certificate in Sustainable Environmental, Energy, and Resource Law. He has recently published an article on better management of fisheries at an international level, and this was to prevent the kind of decline of sharks and general biological functions and diversity. This was published in the Willamette Journal of International Law and Dispute Resolution. Mr. Funk he operates now his own law practice, and it is a general law practice where he also has integrated his interest of environmental law.
Let's see. Good afternoon. I'm an attorney. I opened up my law office just recently, and from Northwest Center of Alternatives to Pesticides, Kim Lavelle has asked me to do a presentation on some of the litigation they were involved in, such as specifically 2 cases that revolved around the regulation of salmon and protecting them from pesticide use. But before I do that, I just want to mention something about NCAP. And NCAP's been involved in this, in protecting the environment from environmental degradation for probably about 35 years now. From protecting the waters, from protecting children, from protecting all kinds of things, but also, as I will mention, protecting the wildlife. I'm going to skip this and go right to the salmon. So I don't know if you're aware, but currently 35 species of salmon are registered as either threatened or endangered. And when they're registered as threatened or endangered, that puts them under the auspices of the Endangered Species Act whenever a government agent takes action. I think everyone's really well aware of the importance of salmon, especially here in Oregon and within the Pacific Northwest, where you have a lot of commercial enterprises that depend on it, as well as Native Americans who use it for subsistence living. The Endangered Species Act, just to give you a little preview right now, is actually, it's an act that has jurisdiction, or actually two agencies have jurisdiction and regulate or implement the Endangered Species Act, which is the Department of Commerce and the Department of the Interior. But because salmon are anadromous fish and they travel into the ocean, that it goes under the jurisdiction of the NMFS, which is the National Marine Fisheries Service. And both of those agencies are responsible for implementing the Endangered Species Act to protect these species. It is the first salmon that was listed as endangered occurred in 1989, and then after that, 25 additional species have been listed as being endangered. And usually when they do this, they'll classify it as an evolutionary significant unit, which is actually the same as a distinct population segment. But when you do, if you read this stuff and you read the material, you'll find them often referenced as ESUs. But it means the same thing as distinct population segments. And so what they do is they'll look at geographic boundaries. And by looking at geographic boundaries, they'll determine how they're going to regulate these certain salmon species, specifically in relation to pesticide discharge or anything else that would affect their habitat or their general well-being. So the legal protection, I'm just going to give you a really cursory view of the law and how this works. And it'll touch on some of what you said too, specifically in terms of citizen suits and being able to have prevailing party fees and being compensated for what you've done. Because a lot of the statutes don't really do that, which I think you've run into. So the statutes that regulate this are specifically the statutes that were involved in these two cases. This litigation that was involved was the Federal Insecticide, Fungicide, Rodenticide Act and the Endangered Species Act. So according to FIFRA, right now there's been over 1 billion pesticides that have been entered into the environment throughout the U.S. And this was actually a statistic that was taken maybe about, I'd say probably about 5 years ago. So at this moment, I'm sure there's even a greater level of pesticides in the environment currently.
That's every year.
Oh, that's every year?
Annually.
Oh, that's annually. Yeah, so, and another thing about FIFRA too is that it is not a statute that was enacted to actually protect the environment or to protect species. FIFRA is a statute that was designed to control market access. So really when it was initiated, it was really to protect farmers or to protect endpoint users from being harmed, but not anybody at the opposite end of that discharge from pesticides. In 1972, which is actually the decade when a lot of environmental law statutes were passed, there were amendments that were made to FIFRA to help protect the environment, but fundamentally, it is really insufficient to offer any kind of help to any kind of organism or to people either. Also, some positives about FIFRA is that the burden of proving whether these pesticides are harmful is actually on the applicant. So that shifts the costs over to these individuals to do that. And then EPA has discretion on whether to judge whether these pesticides are harmful or not, or the ingredients within the pesticides. However, EPA has a huge amount of discretion on this too. So sometimes when they make these judgments, the pesticides, as the litigation found out, actually has an extremely deleterious effect on the environment. Another requirement that FIFRA does is labeling requirements. So each pesticide will have a label on it for what its uses are, what it's able to be used for and what it's not able to be used for. And then there will be use restrictions. Some of the negatives about this, which is that there is no citizen suit provision. So if a citizen wishes to enforce FIFRA, what you have to do is you have to actually sue EPA to be compliant. So anyone that's actually violating these label requirements, you cannot bring suit against them under FIFRA. And that's a big drawback on that statute. Just a little preview of the Endangered Species Act. It's got 5 important sections. I won't really go into it in much depth, but the 4th section is basically the listing section where you go in and you list the species, and the EPA will go in, they have certain guidelines that they go through to determine whether a species is endangered or threatened. And that process actually gives the species the ability to be protected under this act. So whenever an agency takes action, which is governed by Section 7, it actually it implements the Endangered Species Act so that the agency can then be held accountable for its actions. And Section 7, however, only applies to government agencies. It doesn't apply to private actors. Only Section 9 applies to private actors. Section 10 provides exceptions, and then Section 11 provides penalties. And that's where the citizen suit provision lies, is in the Section 11. So the ESA is actually a much better act than FIFRA to actually accomplish certain things, because it gives each one of us the ability to force the government to take some kind of action. I'm going to get to the cases here. So the first case that occurred which NCAP was a part of, was Washington Toxics Coalition, which they sued EPA. And the issue in this case was that EPA, through the Office of Pesticide Programs, goes through and they judge the registration of pesticides. And in order to do this, they need to actually comply with the Endangered Species Act, which they were not doing. And so when they did this, they were required to consult with the NMFS to see whether these pesticides would actually have a harm on any of these endangered species, which they were not doing. And so NCAP, along with Washington Toxics Coalition, brought suit against EPA to force them to go into this. And some of the takeaways from this case that were actually really beneficial was that within this Ninth Circuit, they found that pesticide registration is an ongoing agency action. And so what that means is that any time now that they register a pesticide, it will trigger that Section 7A2, which requires that they consult with the National Marine Fisheries Service. Also, EPA was arguing that under FIFRA that it would not be able to, or if it complied with FIFRA, that it would not have to comply with the Endangered Species Act. And so after this lawsuit, it was, which is obvious too, because FIFRA is not even an environmental protection statute. So it's kind of a ridiculous argument that they were making. So under that, in order to comply with anything, they have to comply also with the Endangered Species Act if they're going to register a pesticide. And as a result of this, now that pesticides are certain pesticides, actually during the consultation process, while they finish this up, there was an injunction that was issued to prevent the application of these pesticides until they complete their consultation with the National Marine Fisheries Service, which is what they're still doing right now. This is ongoing. This case first started in 2003, I think, or 2001, and it's still ongoing. They're still going through and analyzing these pesticides. And then NCAP had to also sue the NMFS because they hadn't actually done anything for 5 years. So when they brought suit against them, it was to compel them to do what they were supposed to do under the Endangered Species Act and under FIFRA. So at this moment, not very much is done, has been done. There's, I think, probably, nine biological opinions have been issued on 27 pesticides at this moment. And they're still continuing this process, so who knows when it's going to really finish. So NCAP will be pushing this along with these other organizations too, like Washington Toxics Coalition and everything too. So it's going to be a constant battle to actually keep protecting salmon. And we hope that everyone else can find a way to participate in the protection of salmon as well. Yeah.
Oh,
Oh,
No questions?
not until later.
all right, thank you.
All right, last but certainly not least, we are going to be hearing from Pete Sorensen. As you know, he is an attorney as well. He currently devotes his practice almost entirely to civil litigation, which includes environmental law. He is a licensed lawyer since 1982. He has extensive experience in environmental enforcement of federal environmental law. His expertise is in toxic torts, specifically pesticides, right to farm laws, the Clean Water Act, Safe Drinking Water Act, the Resource Conservation Recovery Act, and the Endangered Species Act. I know, that's a lot of acts. Sorensen also serves as a county commissioner for Lane County, Oregon, advocating for sustainable economy and protection of human health and the environment. Let's welcome Pete.
Well, thank you very much for coming today, and I want to say first and foremost, it's an honor to be in front of all of you, because I look out on this audience and I see Mr. Kimbrell, I see my wife, Kim Laval, Executive Director of the Northwest Center for Alternatives to Pesticides. I see a great panelists here and other people that have presented. So first and foremost, I want to thank you for being at this conference and giving your time and energy to the reform that we need in this society regarding the devastating effects of pesticides on people. I also wanted to mention that in putting together this panel, I thought the progression, and that's why I said, no, you can't answer that question. I thought the progression of these panelists would be important to explore the issues of litigation, whether that's a good tool or not. And I just want to say a couple of things right away. One is that lawyers, when you're dealing with lawyers, in my opinion, and this is why it was so great that Rosemary talked about lawyers, you need to make sure you have a good relationship with that lawyer, because you will be involved for a number of years. And the way you put together your relationship is a very important thing, to make sure that you feel it is a fair relationship, that it is one that you can sustain over time. And remember what she said, it cost a lot of money. And I think that the delay and the frustration and the fact that the usual defendants in these cases have tremendous amounts of money and can drag things out and can challenge everything under the sun is something you need to really think about before you get involved in it. The second area I want to just briefly mention is the topic of experts. When people call me, often they will say, they did this, they did this, they did this, and I say, you know, those are the allegations. The proof is different than the allegations. And that is a very difficult concept for people to get across. Just because you have an opinion about something does not mean that you can then prove that to a jury or to a judge when the standard of proof is high. So I want to just mention those two things. And then the last is the idea that the public has that the three branches of government, the executive branch, the legislative branch, and the judicial branch, are fundamentally different. That the executive branch and the legislative branch, in modern parlance, we call that the political branches of government. And the judicial branch of government is somehow different than the other two branches of government. And many people from their fourth grade civics class learned that that is a different branch of government, and somehow that is not political. Well, it's totally political, totally political. And that every judge in this country is either the friend of a U.S. senator if they're a federal judge, or they are an elected official that the public has elected, just like they've elected their governor, their senator, their state senator, their county commissioner, or whoever else they've elected. So get rid of the idea that you are in a non-political environment in the judicial system. Kim, in her talk, and Michael Sly earlier today, used the phrase isolation, and isolation is dangerous. And I want to just say that Rosemary's isolation, and the isolation that comes from stepping forward and trying to right a wrong, is a huge part of the psychological part of litigation. You will be isolated for stepping forward to advance what you think is just justice and trying to get justice. And don't underestimate that. I like to think of the tools, the analogy here of a tool. People say to me, well, you've worked in Congress, you've been a state senator, you're very political. So don't you think the best tool is legislation? I said, no. I would like to ask you, what is the best tool to build a house? Hammer? Okay. A hammer will not clear the land to enable you to build the forms for the foundation. A trowel is necessary to smooth out the cement. A goat will not sand the wallpaper, the wallboard. Roundup will kill the weeds, but it might kill you, so it's not really effective. And the Roundup will not hammer a nail into a board. No, and I think the analogy here is, what's the best tool? Is it education? Is it litigation? Is it organizing? Is it money? Is it bodies? Is it people? So what I'm saying is, litigation is a tool, and it needs to be used effectively. And if you don't have the proof, don't get involved with litigation. If you don't have the money or can't convince a lawyer to take your case on a contingent fee basis, or you can't find a statute like the Endangered Species Act that has a fee-shifting statute that enables the lawyers and experts to be paid at the point of winning after they fight you tooth and nail over the amount, then really think it through. Would you be better off with some other tool that is less expensive and maybe more appropriate for that situation? So let me tell you a couple of brief war stories. What's our time running? I don't want to go too far over it. Okay. The first is an example of public interest litigation. And I feel here I am talking in front of Mr. Kimbrell about public interest litigation. That's what his organization does. I'm just in tremendous appreciation of all your great work. The American Legislative Exchange Council is a corporation-funded group that convenes every 2 years in Florida, wines and dines the state legislatures of the 50 states. When I was a senator, I was never invited to such a gathering, so I've learned this through internet research. But they wine and dine these people, and they come up with model state laws. So one of their model laws was called Right to Farm Act. I call it Right to Pollute Act. They didn't take my version of the name. So they've been pushing Right to Farm Acts around the United States. Oregon in 1995 enacted their Right to Farm Act. I might say I happen to know about that because I voted against it as a senator in the legislature. But be that as it may, it was passed by the legislature, signed by the governor, went into law. And what does the Right to Farm Act do? It says if you're involved in normal forest and farm activities, meaning you can use pesticides and you can use fertilizers, and you are farming away and using that, and your neighbor is a victim of that, then if the victim sues the perpetrator, and to use the lawyer words, if the plaintiff sues the defendant, then the trial judge is instructed to throw the case out and award all costs and attorney fees in favor of the defendant, the perpetrator, against the victim, the plaintiff. So our leading case in Oregon is where a billionaire timber company is next door to a millionaire winery. The billionaire timber company is spraying. It drifts over to the wine property, which was not organic, by the way. It wipes out $1 million worth of vines. They're upset. They try to work it out, lunch at the country club. They can't, and they sue. Trial court says, how much, defendant timber company, did you spend investigating this case? Oh, $600,000, experts, where did the drift go, blah, blah, blah. And so, okay, well, let's award all that against the victim. Affirmed on appeal. So 6 couples come along a few years later. Affirmed on appeal means they lost and had to pay the money, okay, the victim. So along comes 3 couples, 3 married couples. I believe they're all NCAP members, and they live in rural Oregon. They are routinely sprayed. They file a suit against the state, not against the tortfeasor, not against the person that's doing the spraying, but against the state for having an illegal law. Trial court throws that out, and NCAP gets a public interest lawyer, me, involved to write an amicus brief. We take this up to the Oregon Court of Appeals. We have an argument. We get an opinion saying, no, the Oregon Right to Forest and Farm Act, which I creatively called ORT-FARTFA in our brief, ORT-FARTFA, my own acronym, which happens to actually be accurate, ORT-FARTFA does not violate Oregon's Constitution and the provision of Oregon's Constitution that's in most of your state constitutions, not in the federal Constitution, that includes a remedies clause. Remedies clause. With all apologies to the women in the audience in 1859, when they made up the Oregon Constitution, they didn't have any Constitution, so they had one from Indiana. They copied it, so it's from the Indiana Constitution as well. And that provision says, all men, sorry about that, shall have the right to a remedy for any civil wrong done to them. Well, what does the ORT-FARTFA do? It stops you from having a remedy. The victims, the plaintiffs in this case, petitions the Oregon Supreme Court 2 weeks later. We lost the case. Dismissed. So right now, if you're in one of these jurisdictions, one of these states that have these right to farm laws, I would really love to talk to you, because we are going to work on creative ways to look at how to position the proper case to invalidate these right to farm laws under state constitutional law. By the way, for those of you who are following the Big Nine, the U.S. Supreme Court, they've been deciding a lot of really bad cases on 5-4 decisions. Most recently, the McCutcheon money is power, power is everything case. And so they would be immune. The federal courts would be unable to attack the constitutionality of a state constitutional provision and keep that away from them, and so that state courts would invalidate these right to farm laws. The University of Oregon School of Law has a research project on this topic that I'm helping with. And just to end on a little more positive note, I mentioned that you know, these cases involve heart and they involve head. You have to have both. You have to have a heart to pursue these cases because you are up against so many options and obstacles. And I will tell you, in my own experience with pesticide litigation, that In this particular case, it was a private case, so it involved the tort law of Oregon, very common to the tort law of all of the 50 states. But basically, if a wrong is done to you, you do have a remedy most of the time. And in this case, my clients were raising little tiny baby Douglas fir trees from seeds. And they had 500,000 of these little tiny 3-inch trees next to a railroad track. Along comes the railroad, not with its choo-choo engine and its box cars and its things that are going on to the other side of the mountain. I remember reading this book to my children. No, this is called a spray train. This has got a 150-foot arm out each side of America's railroad tracks. By the way, in case any of you haven't been walking down a railroad track, do you see a lot of weeds on those railroad tracks? I don't see very many weeds. And in the deposition of the defendant's expert, I said, now, Mr. Jones, how long have you worked for the company? 19 years. And what do you do? I'm in charge of the right-of-way spraying program. And so have you got a lot of experience using herbicides? And he said, herbicides? What are you talking about? I said, well, don't you spray herbicides to get rid of the unwanted vegetation? He says, we don't use herbicides. Herbicides are used in forestry and agriculture. They're selective. We want to kill every living thing. Those are biocides, sir. I got to use that in front of the jury, by the way. But at the time, when I was taking his deposition, I was thinking, wow, he's really devoted to this. So anyway, to make a long story short, we had experts up the wazoo. We had drift experts, we had plant pathologists, agronomists. They said it was because of the water. They said my client's water killed their own trees, but they had grown 10 prior crops of trees using the same water. So that, but we had to be ready for that too. At the end of the first week of a 3-week jury trial, the judge calls me and the other lawyer up and says, how come you haven't settled this case? I had about 200 photographs of dead trees in evidence at that point. And I said, before my distinguished opponent answers, I'd like to just say that it's not his fault. It's not my opponent's fault. His client has a national policy of never settling. They never pay 1 cent to a plaintiff, an injured person, or an injured company, because that's their power. They will not settle. They will wait until the highest court that they could appeal to finally says they're done. And sure enough, after a 3-week jury trial, a very successful jury verdict, they appealed, Court of Appeals, took 2 years for that. We won that. They petitioned for review, for Oregon Supreme Court, denied review, and I will tell you this, my house almost was repossessed by the bank. I had so much time into this case. My clients had gone to 14 other lawyers, and as any lawyer in this audience knows, when a client comes to you and says, I went to another lawyer and they turned me down. I went to another lawyer, they turned me down. I went to another lawyer, they turned me down. You're supposed to say, bells are going off here. Maybe I won't actually be any better than all these other nice people. So I did violate that rule to say that I believe these people, I believe their evidence, I got their evidence. They worked like Rosemary did as an excellent client to help find more experts, and it resulted in a positive outcome. And as Rosemary said, chemical trespass is trespass. Trespass is a tort. It has been a tort since the 1200s in medieval English law, and there's nothing new about that. And I think that what is sad is how long it took these people to get some justice. And last but not least, I'll say that I really appreciate the panel, what they've done here, and the work you did putting into your presentation. I think with that, I'll open it up to our moderator to accept some questions, and thank you very much.
Thank you. Do we have questions? Yes, in the back.
Two questions. One is, can we sue for chemical trespass in our bodies? Now that we're finding, like say breast milk and urine, and I did not ask for it to be there.
Let's see. Well, I think this guy knows. The short answer is yes. You have to have the filing fee to sue.
Filing fee, what is the filing?
You have to pay the court clerk enough money that they will take your case. But that's only a technical answer. Can you sue? Yes, you can. But, you know, all this stuff we've been talking about, where's the proof? Do you have a lawyer? Are they interested in working on your case? Will they work on your case? Do you have the money to pay the costs of these experts? How will this case proceed? There's a lot of things besides a flippant answer like yes or no. It's a huge undertaking. One of the public interest groups I did a case for, involving the Endangered Species Act. They have a committee of their group called a Litigation Risk Committee to determine whether or not, if we lost the case, whether the public interest group would have to pay the attorney fees of the defendant if the case was deemed to be frivolous. So there's a lot of questions that have to be asked before we can give you an answer, because I don't know where those chemicals came from that went into your body. But if it's something you could prove, and you have sitting in front of you a guy that worked for EPA for 25 years, maybe he could tell you that's one of the biggest problems public interest lawyers and tort lawyers have, is causation. Because a lot of experts are very, very smart people. They're professors, they're authors, they've written a lot, and they know that things are complex. And they are not the kind of people that run around saying, yeah, I know that. Of course I'll say that in front of a judge. They aren't. They're very well educated, and they see the complexity of issues. And as plaintiffs' lawyers, or as advocates for people that are trying to get justice, that is one of our biggest problems, is reconciling the fact that we need an expert who will say, those chemicals that came from that corporation went into your body and hurt you and caused you damages. And that may seem like a simple thing, but that is one of the reasons why this is such a complex problem. And I think Rosemary could add to this.
Actually, the first thing I want to say is I'm not a lawyer. So it's really hard for me to gauge that kind of thing. But the proof issue is very difficult. People, I mentioned how they've talked about our cistern in the septic system. I mean, anything to muddle the case, anything to cost more, anything to make it look like that, you know, you don't know what you're talking about, you don't have a consistent story. And when you start looking at the experts, I mean, we actually got lucky. We had a couple of expert physicians disqualified from the trial. And we were lucky. The silver lining on that cloud was that the physicians were willing to get up there and say, well, you know, there's a possibility it might have, you know, those kinds of, you know, these qualifiers. Whereas what happened was that in talking to the lawyer, our lawyer who then had to represent had to do the cross-examination without those physician expert witnesses, he basically didn't have to worry about what his reputation in the medical community would be. And so he really went after the physicians who were on the stand for the defense. But I think that it's really, really difficult to prove those links. I made the sort of quip that you don't have to prove damages, damages being the one thing that the EPA said that you had to do. And, you know, I said if you were bleeding from the ears, but but you still have to make that link that you're bleeding from the ears because of this particular pesticide.
Well, I'm just talking about it being present
I cannot address that at all. I don't know. Do either of you want to say anything more? Yeah.
Well, I just want to make sure we don't have an answer on that one.
I cannot.
No, I know, Rosemary, you don't.
I'll just wrap this up by saying, what are your damages? You know, what is the jury going to say your damages are that you have now proven you have this in your body? You have to prove that you have been damaged, sufficient to where a jury would say you have been damaged and you should be awarded money because of that damage.
Would great numbers help, like if we had 100?
That issue of a class of plaintiffs or a group of plaintiffs, that is a very big thing in environmental litigation, is to show a class effect. And by the way, the Supreme Court of the United States has been, you know, doing some bad things in the employment arena. They had the big Walmart, and they failed to certify a class of Walmart employees. Again, that's another 5-4 decision of the U.S. Supreme Court involving class litigation. They said that all those underpaid female employees of Walmart did not have enough in common that they could not form a class, and so they denied class status to all those underemployed female employees of Walmart. That's an example of a class litigation gone bad. Anyway.
I had one
Okay.
more question.
I think there's a couple other questions. Is it okay if, sorry. Okay. Yeah, sorry, he had raised his hand.
Yeah, my name's Keith Stavrum. I represent Moby Dick Hotel and Oyster Farm, Tabardine, Brother and Chips, blah, blah. We spent $500,000 on attorneys and experts to prove that we've been drifted on in Willapa Bay with oysters, poison. We had all the experts. We had the economic impact experts. We had the endangered species studies that were done that were in Willapa Bay. And when it all got done, we got up to a judge that said, so what? So now I'm sitting here with $500,000 worth of people, studies, damage, drift, documented videotaping of state agencies going, and it drifted. We spent $15,000 to test every time they sprayed Willapa Bay. It's all over the bay. So I'm sitting here with all this stuff, and I'm kind of sick of it because nobody in this good old boy thing, I'm isolated. I feel that. I know how it goes there. It's all oysters. So what's happened is I have all this stuff, and it's enough to do something with, but I don't know what to do with it. I don't want to do it anymore. I'm done. I'm done. When I got that, I mean, I'm a cancer survivor. I went through the chemo, and basically what happened was, should we pursue this? Because my oncologist said, you've been exposed to glyphosate. Out of the 39 lymphomas, 29 we know how to cure if it's chemically induced. And when I heard that, I just went, wow. So I just need to know what to do with this stuff. And where do you go to say, here's a bunch of stuff, you want to do something with it? Because as I heard earlier, there are some other laws that are being broken, but to go down that avenue, I mean, $500,000 on all this stuff, and it's thrown out, and we had the experts. I will tell you, it doesn't matter. And what you're talking about, it'd be thrown out so quick, I don't care how many people you got. It isn't going to work. It just isn't. Because them chemicals could come from anything in your life, is what they'll tell you. You'll never win the case. I just went through this. That's how I feel about it. But I do have all this stuff that's coming to table.
All right, thank you. Sorry.
Can I talk?
Yeah.
Okay, hi. I'm Antoinette Graywall, and I may take your stuff, by the way.
Yeah.
I have a situation going, it's beautiful. It's not toxic torque, but it's all about pesticides and chemicals. I live in a large conglomerate residential place. It's one of the largest in the country, vice versa, first or second place, depending on which the wind blows. I filed a case, it's in Los Angeles. There were 4 major exposures, of which every one of them placed me in the hospital. The first one cost me $43,000 out of my pocket because it wasn't covered, it was complicated, whatever. So the beauty of this case is it's Americans with Disabilities Act, which does the fee shifting, but it also does another thing. I had a contract, an ADA contract that said you could not do any chemicals within a 3-unit radius of me. And your trespass thing might be very very applicable because they've trespassed on me in many ways. Because that unit is mine. I pay for it. That's my home. So as a result, I'm meeting with some major law firm. I got a big one on Monday, and he was my client 40 years ago. He better take this case. I was wondering whether NCAP would possibly just even look at it. I'm not asking you to do anything, but gee, maybe if my eventual lawyer, because it's already filed, and I have so many days to amend, and but it was a big rush for me to save my statute of limitations for that first big one. I didn't want to lose it because that was $43,000. And when you do it under ADA, it's 4 times that amount. So just the first exposure is $200,000, and then there are more. And then on Friday, I had a really good situation going where they wanted to do carpet cleaning right next to me, and I have an expert lined up, and he'll do this all for free. And he's affiliated with UCI, and they basically were telling this major conglomerate, you can't do this, Jory, you can't do this. So they came back, and 5 minutes before, it was supposed to be done on Friday at 10 in the morning, but they bumped it up at 5 to 9. They go, we're doing it at 9. Like, they're totally stressing me out. Like, I want to buy a gun. So what happens is they then proceed to, I want to protect myself. I have that right. I mean, nobody has a right to assault me this way. So as a result, they didn't tell me, but I came back like 4 hours later. I rushed out with my dog, came back. I met with the carpet cleaning crew, and they said, oh, we just use steam water. So these people, and I'm calling them these people just to be ladylike, they wouldn't even acknowledge that they didn't use chemicals. They're bullying me. They're completely bullying me. It's like abuse. It's like, so I'm moving forward. The attorney that wrote this complaint did it to save my statute of limitations, but he mostly practices in Colorado, and it would be just hard for him to be in Los Angeles for all of this, as it probably would be for any other attorney here in Oregon to do something like that. So it'll probably go federal district court because it's ADA. That's where all the good fees and things are like that. So I was just wondering if I could give you a copy, and I redacted stuff because it hasn't been served yet, because we have to amend it, that kind of thing. But it's a real good case as far as the residential.
I think that one of the things this question points out is that one of the first things I want to say is that American law is very state-oriented. So even though I'm licensed to practice law in the District of Columbia and in the Federal District of Oregon, in the local courts of the District of Columbia, in the local courts of Oregon, I'm not licensed to practice law in California. And so one of the things that you will hear from lawyers often is, well, I can't represent you because I'm not licensed to practice in the United States District Court for the District of Los Angeles or the California Superior Court for Los Angeles County. What typically lawyers do in that situation is if you have a situation, a problem in another place, for example, I've done some California litigation or some Washington litigation, I'm going to associate a law firm from that jurisdiction rather than try to do the whole thing from Eugene, Oregon. So that's a common problem that people have in a national and international economy of people using the internet. I don't know, Chris that well, but I think you're an Oregon lawyer, right?
Yeah.
So you're not a California lawyer either.
No.
So, that's another issue is courts, licensed lawyers, court by court by court.
But what about ProHab BC?
That's what I mean. That's what it's called. So if I do a case with a lawyer in California, then I'm going to be admitted in the Latin phrase pro hoc vice means just for that case only. So that's the way that we would typically do cases in different jurisdictions.
This is federal. Does that still apply?
Yes, it does, because federal courts license lawyers court by court. So I'm licensed in the United States District Court for the District of Columbia. I'm licensed in the United States District Court for Oregon. I'm licensed in the District of Columbia Court of Appeals. So my practice has been in these federal courts, because I've done so much drinking water and ESA and other things. But what you're really asking is, to have people that are competent to work on the case, and you have to, interview the lawyers. You have to interview people. You have to. I think sometimes maybe we should have a how to find lawyers workshop at this thing, because there are so many different types of cases. I mean, I started out talking about the public interest litigation we did against Oregon's right to farm law. There was no attorney fee statute. I did that basically for nothing. When you talk about a big case, you better have a very firm agreement on how that lawyer-client relationship's going to go. Even in the best of circumstances, as the guy from Willoughby Bay just pointed out, even in the best of circumstances, things can go wrong in litigation. So.
The beauty of this is, it is ADA, it's not toxic tort, it's simply violation of contract. It's like, almost like contract law that's buffered in under ADA issues.
Yeah.
So this is a good one, because it would take care of that residential problem. I don't know of a lot of residential cases that have gone forward in this country.
Okay.
ADA litigation, George is sitting next to you, but I think ADA litigation is growing in the environmental context.
I haven't found anyone that does it.
Okay, I think because we are nearing the end and there's a few other hands. This gentleman here.
Just an easy answer. How many states have right to farm law? And is Washington one of them?
I don't know if Washington is one of them. I thought that I read somewhere it was in the neighborhood of 16 states, but I don't know. If you have one, come up to me and talk to me about it, because I'm very interested in this area.
Okay.
I was just going to add that we get a lot of calls from people at NCAP who are wanting to find lawyers. And so we try to go through this, hear their story and explain that it really is a state-by-state situation. And so we refer them to the Bar Association, and many bar associations have lists of lawyers who do different kinds of law and can help people find lawyers who have done pesticide cases. So I just wanted to mention that. And if anyone has any other reasons, let me know.
Yes.
I would like to add one more thing, just briefly. The ad hoc coalition and Washington Optics Coalition, we sued to stop the use of 7 in Willoughby Bay. We went to the Pollution's Hearing Board after a long, drawn-out thing, came to a settlement, phased it out in 2012. This last 2013, they sprayed. There's nothing you do about it. You'd have to go through the whole thing again. I just want you to know, no matter what avenue you take, you're taking on a chemical company. I hate to say it, it's gonna be a tough one. A cattle guy had a bunch of cattle, they sprayed, they ran down, and I was at a weed board. And I asked him, I said, "Do you ever have a bunch of stuff die like my oysters?" He goes, "Yeah, my cattle." I said, "What'd you do?" I sued the chemical company, they settled, but he was a cattle rancher in Washington State. So there's a difference. So the way you approach and who you go after, maybe it's not the agencies, and it's always stuck in the back of my head, maybe I made that mistake. Should have just went after the chemical company, settled, kept it quiet.
And I don't agree that you can't win. I do agree that it's very difficult. The cases have to be carefully selected. You have to have excellent experts. You have to work really, really hard. It's not for everybody psychologically. It's certainly not for everybody financially. And I just think that you need to be as objective as you can about it. I know that Rosemary has her own story on how much money it cost to get her own injunction in Colorado. I mean, it's a lot.
And there's no enforcement.
That's right.
So when which he has already done, violates it, it's opening that can of worms again.
Yes, in the back.
So I'm Susan Hagley. The other angle that I do expert witness work, and the other angle that I'm seeing in some of my work is to look at property values, the decline in property values. So you don't have
Yeah.
I think another creative idea, and I think that's an excellent idea, to minimize these proof problems. One time I was approached by a group of activists who wanted to stop roadside spraying in a particular county. And we signed up maybe 80 property owners under Oregon's law that allows you to sue for trespass. But you have to give a notice, a 10-day notice before you sue, and you have to agree that your damages are under $4,000. So 80 people put out a notice, big stack of them. We had a press release and everything. And we delivered these 80 $4,000 notices to the county, and all we had to show was the chemical trespass. We didn't have to show any damages. We just had to show that the county spraying would affect it. The county ended their spraying program when they got our notice.
Gosh, kind of even. So.
We're from the island of Maui, which is, they're looking very successful at being able to get on with the election of, to be able to put a moratorium on genetically modified plants, which is genetically modified foods in Maui. We are expecting to get sued back. This follows in the tail of the Kauai situation where the Kauai citizens and the judge said, well, you have to let people know what you want to spray, and you have to have a buffer zone. And so they're suing that this is interfering with their right to farm. But there doesn't look like there's this big law already that tells you right to format. So
Yeah, they have a right to farm back.
it does.
Yes, it does. Just hold on.
Well, I've been asked to help prepare us for the fights that are going to come forward, and I was asked by Free Speech for People is going to, they want to find a lawyer in Hawaii that they can work on writing an amicus brief for the Kauai situation.
Okay. Just because we are nearing the end, I think there are a couple other people, so we maybe can continue that conversation.
Answer. I just Googled right to farm laws,
Y-
in case anybody's interested. It says right to farm laws in the United States, sometimes called nuisance laws, deny nuisance suits against farmers who use accepted and standard farming practices, even if those practices harm or bother adjacent property owners or the general public. Nuisances may include noise, odors, visual clutter, and dangerous structures. Every state has some form of right to farm law. Every state.
Yeah.
Are there any examples of cases that have been won against big, big chemical companies?
Yeah, absolutely. Yeah.
I've won a couple myself.
Two or three of them.
Uh-huh.
Behind you, Doctor. But there's the Bates case in Texas where they killed off a bunch of the peanut farmers, something like that, crop.
Yes.
Basil. They didn't test it, or they didn't test the herbicidal activity in a certain pH soil, or they did, they knew about it, they didn't tell the farmers, that's what it was. They knew about it. So it was something they knew about. Then the big case, DuPont's oust herbicide was sprayed
hold on.
Not sure which ones we're going to use yet.
Well, and
Just-
it might be worth noting that in these what I might call damage-like cases, you're better off with statutory federal environmental law, the the Clean Water Act, or other statutes that are the Endangered Species Act. You're better off with a statutory framework where they violated the law, the winner gets paid the attorney fees and expert witness fees, and you're better off with that than you are trying to litigate a damages case when really the amount of damages aren't that great, and you're trying to kind of make the damages bigger. And I think one of the bad things that goes on is when people try to make a damages case, which isn't a damages case, into one, when what they really ought to do is enforce one of our 15 or so federal statutes that provide for citizen enforcement. And certainly if you're motivated by having the law enforced and the deleterious activity stopped, you're more likely to get an injunction, that is to say an equitable relief to stop the bad thing. Because keep in mind, tort law since the 1200s in England does not give you really any right to stop the behavior. It's all about compensating you for what happened.
Of course, in the case of FIFRA, that's a little challenging because, as Chris pointed out, they don't have a citizen supervision. So that's why you do have to get a little creative in the pesticide area and look to maybe Clean Water Act, Endangered Species Act. So, I mean, this is what we all, and why we depend on you as organizations to bring the individual stories to us so that we can all work together and find the best way to, achieve that. Okay, I think we got 2 more questions, one in the back and this one, and then we're at our wrap. Oh, I'm back.
Department of Environmental Quality was right around the corner. So I just went in and interviewed the lady. She didn't even know about the neon pesticides, which I thought was very interesting. But she did the water, and she didn't know, they don't test for pesticides.
Right.
Right. But she did enlighten me that states can actually adopt different levels, acceptable levels of pesticides than the EPA. They usually don't because they don't have the money for that. But let's just say California said 0 glyphosate or 0 nicotinoids. Can the EPA override that?
No, it's a floor, not a ceiling.
Yeah, each state can establish their own standards. Most states don't. California is one of the few states that does have slightly higher standards than the federal standards. But in say more regressive areas of the country like Idaho, they actually did away with all their standards for a few years just to have just the federal standards. But it is a floor, and you're right, politically, the citizens of states have rights to ask their legislature or their regulatory agency to increase their standards and make it safer in your state. So you have that right.
That would render GMOs that are genetically engineered to withstand glyphosate completely useless as well, if we could lower the standard. I mean, you know what I mean?
The one caveat I would have is that the federal pollution laws, whether it's noise pollution or air pollution or water pollution, they're all about establishing the allowable rates of pollution. That's what they're all about. Our friend from EPA, a retired friend from EPA, that's what EPA does, is they make rules for maximum contaminant levels in drinking water. I've done like 15 drinking water cases, and the drinking water standards are set by EPA. And very rarely do states establish standards that are better than EPA standards.
They could.
Yeah, states can.
Well, in Hawaii, what I have learned is that in their state constitution, the last 50 states, they have this thing about not being able to, having to protect the island, the spirit of the land, that nature actually has rights. And that's where this attempt to create a moratorium on GMOs is coming forward. I mean, some of that spirit is the pesticide thing as well.
Mm-hmm.
But I guess there's no, if there's no other state that has this, then I guess there's no legal history, huh? Is it worth this, or, I don't know.
Some states have environmental protection constitutional provisions. Hawaii's is Article 11. Yeah,
great.
Maybe that's a good way to end this. You know, go out and start working on your state constitution and get it amended to create a right to a clean and healthy environment.
Yeah.
As fate would have it, I actually wrote one for Oregon a few years back.
Thank you, everyone. We hope this has been helpful.